I'm Matt Bishar with REIT.com here in Boca Raton, Florida for REITWise 2014. Joining me is Jim Hanks, partner with Venable. Jim, thanks so much for joining us today.
Good to be here, Matt.
Here at REITWise, you moderated a panel focused on say on pay, which is obviously a hot topic now. What steps do you recommend that a REIT takes to win its say on pay vote?
Well, first and foremost, the REIT, through its compensation committee, should design a good plan with the key emphasis being on pay for performance and also rigorous application of whatever metrics it is that the compensation committee thinks will best promote pay for performance. So starting with a good plan is first and foremost. After that, it's important that the compensation committee run the process as much as possible and be perceived as running the process. Third, I think I would say that, and I haven't seen this as much as I would have expected to, I think that the compensation committee has got to get very intensely focused with its independent consultants on whether the consultants think that this plan that has been designed by the comp committee with the consultant's advice will get the requisite vote for say on pay purposes. And so I would encourage comp committees to really get the comp consultant to go on the line and say, yes, we think that this will result in a favorable vote. And of course, for this purpose, a favorable vote really means 70%, because that's what ISS benchmarks as the percentage that they want to see if they're not going to drill down further into the plan. And finally, I would say that detailed, transparent disclosure of the comp plan and its effects is very, very important.
And what are some of the pitfalls that companies need to be wary of in terms of structuring executive compensation?
Well, I guess the first pitfall I would say is not doing any of the things that I just mentioned. But after that, I would say that to the extent that a comp committee wants to depart from what is accepted industry practice, either in terms of the substance of the plan itself or the process by which the plan is arrived at or the disclosure, it should explain fully why it is departing in those regards. And in particular, to the extent that the comp committee thinks that there's something differentiating about its company or its CEO or any of its named executive officers that result in some sort of departure from accepted substance and process, it should explain the differentiators fully so that the shareholders can appreciate why it is that the committee is recommending something that may not be fully congruent with accepted practice. And finally, I think it's very important for the comp committee and the board to keep a sense of perspective. The ultimate goal of any REIT board is to act in the best interests of the company, not to get a high percentage on the say on pay vote, not to get a high quick score rating, not even to be reelected. The goal, and this is very clearly expressed in the Maryland statutes and elsewhere, is to achieve what the directors believe is in the best interest of the company. So if the directors think that a particular comp plan, even though it may not meet ISS's or other people's views of what's a best-in-class comp plan, if they think that plan is the right plan for this company and this group of executives at this time, then they should do it. and fully explain it, and let the ISS chips fall where they may.
Jim, thank you so much for joining us today.
Good to see you again, Matt. Thanks.
For more on this and other REIT news and analysis, be sure to visit REIT.com.